Hello everyone, this is the second short video that I'll be recording. This one I promise will be shorter than the first because that video turned into a bit of a prelude to some of what I'm going to talk about in this current video. Now the first concerned the fact that in Scotland today it is actually quite difficult to protect the personality interests of the living, certainly more difficult than it ought to be when one considers the historical background to Scots law and the position of the Actio Injuriarum therein. If, however, Scots are able to better rationalise the law of delict and to develop our native connection to the Actio Injuriarum so as to protect the personality interests of the living, then logically there is actually a mechanism within our legal system which would allow for the protection and preservation of privacy interests of the dead as well. And this mechanism rests on the rule which is often cited in the courts of Scotland, albeit, as Professor Gretton notes, the logical consequences of this rule are hardly ever followed through. And that rule is that the executor of a deceased person's estate is eadem persona cum defuncto. That is, the executor of a person's estate is the same person in the eyes of the law as the deceased. In other words, the personality of a deceased person in Scots law survives the death of the natural person in whom that personality was imbued. This survival of personality comes about because human personality is in the same way as corporate personality, or what we might term artificial legal personality, nonetheless still a institutional normative legal concept. The legal system itself decides who persons are and what they can do. So with the net effect then that any given legal system can of course deny personality to human beings, and in turn can allow personality to exist where non-human constructs exist, such as potentially trusts, but certainly Scottish partnerships and incorporated limited companies. So within this framework, within the framework which recognises that personality is an institutional concept, the idea that certain elements of personality can transfer from a deceased person to their executor is not as absurd a claim as it might seem to be at first instance. But of course, the idea of this has not fully developed in Scots law, because indeed, as Professor Roderick Paisley of the University of Aberdeen has pointed out, the law of persons in Scotland is in a wee bit of a state. No one really talks about the law of persons, out with perhaps the context of corporate personhood, with the net effect then that the last person in Paisley's words, the last person who ever wrote anything about the Scots law of persons that makes any sense, is in fact the Roman jurist Gaius, writing in about the 2nd century CE. So again, with this in mind then, I have written what was supposed to be a short paper on the subject of the Eadem persona cum defuncto rule, and submitted it to Edina ahead of the occurrence of this conference. Hopefully then, if you've had the opportunity to at least take a look at that, you'll get a better idea of where my thinking is developing in this regard. The paper itself is really quite rough at the moment, but nonetheless it expresses a mechanism which could potentially be used by Scots lawyers even today to allow a temporal representative of a deceased person to take action to vindicate not only the privacy interests of a deceased person, should we better develop our law pertaining to privacy in this jurisdiction, but indeed any non-patrimonial or dignitary interest of a deceased person which is affronted either before or after the death of that human being. Hopefully you'll find this to be interesting. Hopefully we'll have a very good discussion at the forthcoming session. Thanks for listening, all the very best, and I'll look forward to meeting you in person.